Wonderful. All right, let's get into it. So, everybody, welcome to this live conversation, and of you listening to the recording, get on our mailing list so you get, at the very least, you get invited to our live conversations. And I'm super excited to be joined by Jaryd Green. We're gonna riff on tax planning and estate planning for real estate investors and other people in our demographic who often real estate investors also tend to be high income earners and entrepreneurs. So we have some, you guys can ask your questions live. We're gonna just talk about a little bit and type your questions in the chat or raise your hand. Everybody's in the meetup format, so you can ask your questions. So Jaryd, first, let's start off with you. Well, actually, before we get into this, for anyone who's interested in using our services, obviously go to Mark Perlberg, go to markperlbergcpa.com. You'll see a link to sign in for an intro call or to fill out an application to see if you're qualified as a client. And also send us talent. We're always hiring. Please, even if you don't qualify and you send us a client, I'll make it work. So find us some talent, or if you or someone you know wants to join our team, you'll find a link to apply at markperlbergcpa.com. All right, let's get into it. Jaryd, introduce yourself in 60 seconds or less.
All right. I'll do it in even less than that, hopefully. So I'm Jaryd Green. I am an attorney. I am located in Duluth, Georgia, as my main headquarters. I'm actually born and raised in Gwinnett County, Georgia. I'm licensed to practice law in Georgia, Alabama, and Tennessee. I often have clients that are across state lines, and so I have to be prepared kind of across state lines from time to time, but it doesn't necessarily mean I can give a legal opinion in those states. Those are just the three states I'm licensed in. As stated, I'm born and raised in Gwinnett County, Georgia. I've been here all my life. Went to University of Georgia undergrad. Go Dogs!
There we go.
And I love helping small business owners. I love helping families. I love helping those people that feel like they're in a solopreneur, entrepreneur, just getting started. They're not sure what questions to ask. They're not sure who to put on their team. Do I need an attorney? Do I need a CPA? The answer to most of those questions most of the time is yes. And I value myself as one of those members of those teams for my clients, and like to partner with people like Mark, who they're part of your bigger picture team to help meet all of your financial future and protection goals, so to speak. So I value myself as what I'd say like a protection expert, but transactional attorney, real estate closings, estate planning, and business representation.
Okay, great. Now, for anybody listening in, I'm going to ask some basic high-level questions here, and we have until 11:45. So I want you to either ask your questions in your chats before you go live or raise your hand, so I get a feel for how many questions we have from the audience before we jump into the audience questions. But let's talk about first,
Okay,
let's talk about
sounds
some of
good.
the
Thank
very
you.
basic things here.
You're welcome.
Can you
Thank
tell
you.
us about when should we start thinking about estate planning?
The day you turn 19 years old, no, 18 years old. Really, it shouldn't be delayed. I think people are scared to start thinking about their estate plan because they fear their own mortality. They fear those types of questions. What I like to tell people is it's not necessarily something you can put off, because you don't know when you're going to need the planning in place. So every day you don't have planning done is a day that you're kind of just rolling the dice, frankly. And so I would say the sooner the better. It doesn't have to be something robust. It doesn't have to be trusts that own other trusts and, crazy right away, but just a basic will, basic power of attorney, basic healthcare directive. Start with that, branch out as you can, make things more complex as your life changes. But those differences happen routinely. Your kids grow up and you want to add them or change them to be your executor instead of your friend. Little things like that, as they happen, it should be looked at least every 2 to 3 years.
Okay, great. Now, let's talk about some common misunderstandings and mistakes that people are making, especially with our demographic, which is high income earning real estate investors and entrepreneurs.
So the biggest thing right now is in liability exposure. So most of the time, it's twofold. One is you're a real estate investor and you own these properties directly in your individual name. Big problem, because if something happens, slip and fall, some accident on site, yeah, you have insurance, but if that person comes after you personally, your personal assets are exposed. So there are several ways to protect those assets. One of those would be using a company structure, so an LLC and INC. And then another one of those ways is to use a trust. What I actually like is combining the two. So I do an LLC that is then owned by the trust. So you have a holding company essentially that owns your properties, and that's the LLC. And then people aren't going online and seeing that your LLC is owned by a trust. That's an internal document that your trust owns that LLC, but it protects you, kind of an additional layer of liability protection. But first and foremost is the LLC, and that can be per rental property. But I usually like to do a holding company LLC and then sub LLCs based on if you have a lot of rental properties to kind of separate and segregate the liability in each one.
And this is stuff you can start doing now, not if not for the purpose of estate planning, also for asset protection. Now, here's a question I've been wondering for a while. And I think the audience would appreciate this because we can do our own research into estate planning and tell clients about the basics, using trust to avoid to avoid probate and some other tax strategies. But when it comes to finding the right professional here, because we're not going to treat ourselves as though we're authorized to do estate planning. And there are certain CPAs who may specialize just in estate tax planning. And also there are nuances state level. So, when in California or New York or any other states, as far as the exemptions for what you're going to be paying tax on for in your state, there's all these nuances, which has led us to say, find someone local. But I don't know what the best answer is, and I want to get your answer on, for someone who's thinking about estate planning, how do they find the right expert, legal expert and resources to make sure they're doing this right?
So I would say that word should be plural. So it should be experts, especially if you own properties in multiple states. So, I have a client that's in New York. He also owns a lot of property here in Georgia. I'm handling his Georgia stuff, but I'm one member of his team that's handling across the board because I'm not licensed in the state of New York. New York has state estate tax, whereas where I am in Georgia doesn't have state estate tax. Now, we all have federal estate tax, and those exemptions are set to change at the end of 2025, which I'm sure we'll get into. But for him, he's worried about his New York state tax exposure because he has a lot of assets up there. And so he has a New York attorney, he has a Georgia attorney. It gets very expensive very quickly when you start adding experts. But what I'll say is most importantly, whether they're local, whether they're national, is you need to be able to be with somebody you trust, spend some time. Don't hesitate to vet people, ask them questions, have meetings with them, have multiple meetings, ask multiple questions. You should feel fully comfortable, because the last thing that you want to do is, I just need to put something together, I don't care. Well, you want these documents to be with you for your life, and you want to be able to change them as needed, revise them as needed, update them as needed. And that's the most important thing, is finding people on your team that can grow with you. Probably not somebody that's 90 years old and is about to stop their law practice. That's probably not who I would recommend. Someone that's your age or close, has enough experience, you feel comfortable in their expertise, but someone that can kind of grow with you. That's the most important thing.
Okay, great. Because because I know that you would be qualified to advise on the federal level of any issue.
Right.
So let's say someone's listening here and they're in Ohio, and they really like some of the stuff you say, but you're in Georgia. You talked about Georgia, Alabama, and Tennessee. Do you think that if their situation, does it depend on the situation, or would you be able to help someone in Ohio with moderate level of complexity, or is there a scope of complexity where you say, okay, you need an Ohio specialist? How does that work for someone a little bit outside your territory?
Yeah. So as far as somebody actually, drafting the documents themselves and signing the actual estate planning documents, I'm only going to be able to do that in the states I'm licensed in. Now, but if it's something where you want me on your team, you want me to ask certain questions simply because you don't know the questions to ask, I'm happy to be an asset in that realm. It's just, can I give a legal opinion or not? Do I have E&O insurance that protects me from, malpractice, things like that? So that would be, if it's somebody with only Ohio assets, they're going to want to get an Ohio attorney. But I'm also happy to ask that attorney questions. Like, if you trust me more, I would rather you ask the questions through someone you trust that can convey that to, the proper entity. I engage other attorneys all the time. To me, it's not a competition. Like, I want more attorneys rather than less. I want more CPAs rather than less. I want more financial planners rather than less, because I'm a team person. So like, that to me is the most important thing, is that you, the client, you, the customer, gets fully and properly taken care of. So
Right. So, you may have an instance where you're advising on it, but then you leverage an attorney at a local level
that's
because
right.
you're not even authorized to practice in that state to write those
That's right.
documents. Okay,
That's right.
great. Now I'm gonna, before I jump into some more questions, I want to see if anybody in the audience, you can use the icon or just put your hand in front of the screen or raise your hand with the icon. Does anybody have any questions? You can raise your hand, and we can get to some audience questions. We got anything in the audience? All right. Well, we got a decent sized audience, but that's all right. You can, when you're ready, you just let me know when you want to talk. One person asked for your contact details. You can just post that in the chat.
Yep,
Uh,
will do.
so let me share with you some of the things. So let's talk about some of the basic stuff that people should know about. And now here's an example where estate planning and asset protection planning is somewhat is well aligned here. So one of the challenges we see is when there is no planning, you have an issue with probate, which is a long and painful process, an expensive process. And we can avoid this by putting the assets, just as you've described. If the assets are owned by a revocable trust, which is what we typically use, because irrevocable trusts introduce new layers of complexity, and it will maybe eliminate some of the tax benefits of real estate. But if we put our stuff in a revocable trust, and that helps us make passing on our assets to our heirs more effective and more smooth. What are some other key things that some of our audience should be thinking about?
Yeah, so one big thing is, if you have business interests, those are personal property interests, at least in the states I'm in, at death. Meaning, if you don't have plans for those business interests, they're going to also go through probate. So if your shares, your membership units are not in the trust, for instance, those could be exposed and have to go through probate, which is a problem. As you mentioned, probate, the biggest thing is not just the cost. I would say it's actually more expensive to have to go through probate for your heirs and beneficiaries than it is to actually set up a revocable trust. So why not do the trust? But really, it's the time. It's, I've had nightmare probates that last 8, 9, 10 years
Wow.
before assets can actually pass. That is crazy. And it's also, it's not up to you at that point. So I look at trusts as the ultimate tool to bypass the probate process, but really for privacy. I think a lot of people have misconceptions. They think trusts are only for very wealthy people, or they're very hard and difficult to manage and maintain. And that's just not the case. They're very straightforward. They're very private. Nothing gets filed publicly. And that's one of the biggest, benefits to a trust is unless the state law requires that it be filed somewhere, it isn't. And that's also, we're not, probably won't get too far into the new FinCEN rollout stuff in the business, but we can talk a little bit about it. There's this new, very draconian law that went into effect January 1st of this year, where all existing LLCs and corporations, all business owners, have to report their beneficial ownership information with a federal government agency, which is FinCEN. It's the Financial Crimes Enforcement. They're a sub-department of the U.S. Treasury. And for new businesses, new entities created this year forward, they have 90 days from when their business is created to file these forms. And then for any existing business, they have 1 year from January 1st. So they have until the end of this year. For some of my clients, I'm telling them, hey, if you want to roll the dice, there's a lot of legal challenges nationally right now against FinCEN. There's a lot of groups that are suing them, saying, hey, this is unconstitutional. I'll not say my personal feelings about constitutionality. I'll just say that, there are opportunities to roll the dice a little bit and wait and see what happens with some of these court cases before you actually file and send your photo government issued ID, your EIN and social security number, all of your mailing and forwarding address, all your information out there, and you're putting out on this supposedly private, protected government database. So that's a little bit disconcerting for people. The penalties for not filing right now are listed at $500 a day or up to 2 years in federal prison, which I don't think anybody wants. But that's one of those biggest things right now is looking at how your business interests are going to be treated at death, and including your business interests in your actual overall estate plan. I think people forget about it. They think, oh well, my business will just pass to either my partner or my spouse or my kids. But if you don't direct it, it's not going to pass just willy-nilly. You have to actually direct where it's going to go, and you have to plan for that.
Okay, cool. Well, we have a question from the audience, and that question is there a disadvantage of having a trust?
A disadvantage to
Administrative
having
work?
a trust. Not really, especially not during your lifetime, because a revocable trust, you're not going to be treated differently from a tax perspective. You're going to be taxed at your individual rate the same way you would be if you didn't have a trust. It's just in addition to your regular return. So there's not a ton of like overhead in terms of administrative or complexity. If you did have something where you got really complex, you can always put a corporate trustee in place. Or in Georgia, we have what's called a trust protector as well. That can be a separate entity where if you felt like a trustee was not able to do their job all the time, you could have a corporate trustee as well that comes in and is a fiduciary on behalf of your trust.
So, and we have a lot of clients in Tennessee, and one of the challenges is Tennessee franchise and excise tax. So, when you have an LLC, they penalize you for it. So we're exploring the possibility of using a trust in lieu of LLCs in certain situations. I mean, being you're in Tennessee, we'll have to maybe chat about that offline and see if that'll help satisfy their asset protection goals.
And in the franchisee space, so I represent a lot of franchisees, have franchise clients all over the country, which is why, crossing state lines is always at the forefront of my mind. It's like, yes, I'm counsel for this company that's based in Georgia, but they're buying 6 new stores in, Indiana. So what should we do about that? The biggest thing with franchises is you're having an additional layer of franchise control. So you have a franchisor that you're going to have an FDD, you're going to have a store development agreement and a franchise agreement that's going to dictate, hey, at death, this is an immediate default under the franchise agreement. If you die, you don't have a will or a trust in place, or, it's not clear, if you have 4 partners, for instance, and everybody's 25% and everybody's, the approved franchise LLC, well, what happens if one partner passes away? So in a lot of franchises, it's built into their structures. That's an immediate default under the franchise agreement. Big problem, big red flag. So what we like to do is, at least in the holding company side, so if I have a group like that, like I have a lot of restaurant franchisees, what they do is they'll have an operating company. And if they're not owning real estate, most own real estate and the operating side. But in the operating company, what we'll do is we'll have their LLCs that's like their personal direct LLC, that they're either a single member or them and a spouse. That will be the actual member of the overall franchise holding company that's the approved quote unquote franchisee. That can be owned by individuals, by trusts, anything else, usually without defaulting on the franchise agreement. But again, that would be franchise by franchise specific. Franchise agreements are not all the same, but they usually run anywhere from 20 pages to 2,000 pages. It just depends on how much is disclosed by that particular franchise.
Right. So we were talking about in Tennessee, there's a very unique tax called the franchise and excise tax, and it's not just on franchises, unfortunately. It's on anybody with an LLC. So even if you are a real estate investor or you own a business, As soon as you have that LLC, you got to worry about the franchise and excise tax or see if you qualify for the for, for an exemption from it. So they pretty much penalize you just for having an LLC. So it's
Right.
like Tennessee sounds so great because there's no state taxes, and then you find out there's all these they slip in this franchise and excise tax, which can be really painful for some of our clients. Um, so it's not really a tax-free state for a lot of business owners, unfortunately.
That's right.
But let's talk about for some let's talk about when to we had a question here. So when do we choose between an a trust and an LLC? And I imagine your answer is you want to do both. But let me hear your answer.
So I would have an LLC that is owned by a trust. And depending on how many properties, I would even potentially have sub LLCs that are owned by a management or holding company LLC that's then owned by a trust. And I have several different structures. It really just depends on how many layers and how many, state um, filings you want to have to go through. I've got clients that have 60 to 100 companies, and then I've got clients that have two, and they are the same size client, same size revenue, same size property holdings. But the one with two is a lot more personally exposed than the one with 60.
Mhm.
So that's kind of where you want to think about it. It's you can have as many LLCs as you want, but at the end of the day, you still have to be able to manage that comfortably and not just, you know, rely on, oh, well, I think it's just going to pass this way and just assume that it's going to pass a certain way. You should direct it accordingly. So, but my go-to is usually going to be an LLC owned by a trust.
Wonderful. Okay. Now let's talk about some tax. We're gonna go into some more client questions, but first we gotta geek out on some tax stuff because I'm here. And so one of the things we think about here is when you are thinking about death or a family member dying, you have some tax advantages. You get the step up basis. You get a step up basis in your real estate, in your partnership and S corp interest, which can really be beneficial and can be wonderful for having future depreciation and mitigating capital gains. You don't get a step up on your C corp stock. So, you'll often find people inheriting their grandma's stock and the basis is minimal, the cost basis is minimal and it's like pure gain here. But there are some things that we can do to optimize the situation. One is if you're, the simple thing to do is just if your seniors or your elders own property and they want you to take them over, let them hold on to the property until you can inherit it and get that beautiful step up basis. Some other things you can think about though are now I've never done this, but one idea people have thrown at me is giving a percentage share of your business or a percentage of your real estate or gifting a portion to your elderly, and then you can inherit it again and get the step up basis. We haven't done those recommendations because that's a little bit outside of our specialization, but I've heard people discuss the benefits of having those types of assets that'll get a step up basis into their parents' names, and then they can inherit it. We haven't made those recommendations. I'm curious to hear your thoughts. And then before I overload this conversation with my own thoughts, another topic of conversation is that once we reach a certain threshold, and they are different at federal and state level, when you inherit a certain amount of assets, you may pay taxes on it. So you can look at the exemption amount by which you can gift off and start offloading some of your assets to some of the people that are going to inherit them eventually to prevent that future estate tax event. Now, what are some of the things that you think about, and what are some ideas and comments you have on some of the thoughts I have?
Yeah. So the biggest thing is kind of towards that last portion, which I think actually answers the first portion of the question, which is gifting strategies. So really, I don't get heavily into gifting until I have a client that's net worth requirements is going to show that they're going to owe the federal estate tax. So federal estate tax exemption right now is over $13 million for an individual, which if doubled to a spouse inclusion would be over 26 million. That sounds like a lot of money, and it is for a lot of people. However, that's about to be more than cut in half at the end of 2025. And so we're in prime time. Like if y'all are thinking about doing estate planning, go ahead and do it before 2025 or get your appointment on the books and start talking and thinking and drafting and reviewing this, because 2025 for estate planning attorneys is going to be insane, because everybody's going to hear about this. There's going to be a big flood in information. And so everybody's going to be seeking out all these estate planning attorneys all year, trying to maximize, because what's going to happen is the estate tax exemption is going to go back down to pre-2018 levels, which was 5.5 million for an individual, which is going to be adjusted for inflation. I think not everybody knows exactly what that is yet. My guess is probably like 6.3, 6.4. That more than cuts it in half. That's a big deal, because there are a lot of businesses, a lot of companies, a lot of individuals. Maybe they're not going to have 26 million, but by the time all their retirement income, but by the time all their investments and everything come to fruition for the entirety of their life, they are going to be around 5, 6, 7 million. And that is going to impact them, because the federal estate tax right now is set at 40% of anything above that exemption amount.
Wow.
Why would you pay 40% estate tax on something that you could pass tax free in a trust? And so the trust becomes that vehicle, right? The trust becomes not only am I bypassing probate, but I'm also going ahead and I'm putting certain of these assets into a trust that, I'm not necessarily, it's not a tax avoidance, but you are protecting those steps up in basis. Now, the questions that I get, and you mentioned it briefly at the beginning of the call, revocable versus irrevocable. That's when those irrevocable trusts do become a lot more valuable, is when you have a dynasty type situation, or you have a situation where your value is already going to be above that threshold. That's when we start doing this giftings. That's when we start doing annual gifts. We start doing gift properties back and forth. I've got several clients that are already over that threshold. So they're like maximizing their gifting strategy up to that exemption before that exemption gets cut in half. And so that's the part, those are much more customized one-on-one plans. I don't recommend irrevocable trusts lightly. They are irrevocable. They are a lot less forgiving. They are a lot more strict. They are a lot more complex. And so you have to be very careful. Like, you have to be ready to part ways with that money and not touch that money again. And so it is almost liquidity based. If I have a client that's mid-career and they're already at that threshold, we're going to start looking at irrevocable trusts, because they're not going to simply stop working tomorrow. They're not ready to retire yet. They've got 20 more earning years where they're still investing. They're still running their business. So that is where the irrevocable and gifting strategies are really coming in helpful. But for right now, absolutely. Annual gifting, you can always do. It still goes against your contribution into what you're doing, but you do have, I think it's 16,000 this year, or 15.5 or 16, right at it.
I think it's around 17, but it changes every year. So
so it goes up a little bit every year. If you have a bunch of beneficiaries that you want to go ahead and gift to, go ahead and do it. There's no penalty on that. But as far as the larger scope structure, that's really the gifting strategies come in. We start talking about irrevocable. Another offset is kind of it's what's called an ILIT, or an irrevocable life insurance trust. So that is a specific irrevocable trust that if somebody knows they're already going to have an estate tax burden, they can go ahead and plan for that by setting up a separate trust. That trust's purpose is really to cover their estate tax burden. So if they know they're going to owe, like if they're 50 million net worth and they know they're going to owe 40% on 25 million because they're over the 26, they're married, we can go ahead and offset a lot of those by setting up an ILIT that works with their regular revocable trust. It's not an either or, it's a both and. So I would always recommend, at minimum, revocable trust. Well, really at minimum, POA, advanced healthcare. But if you're talking about trusts, then we start adding a revocable trust first. And if your net worth dictates it, where you need to get smart with gifting, then we're looking at dynasty, irrevocable, and/or ILITs, which would be the life insurance.
So now this should raise some eyebrows now. So if you don't do estate planning, some of these folks, and maybe some of your parents or grandparents, could be at risk of losing 40% of their assets to taxes. Are we talking about federal? We're not even talking about state yet, right? Because the state
just federal. Yep,
just federal. So the state may want to take a piece of this too.
Yep,
So this can be, incredible. This could really impact your ability to have that generational wealth. And the revocable trust helps out with probate. But to my understanding, there's no real tax benefits when it comes to estate planning with a revocable. You got to put the stuff now in an irrevocable, and that kind of that serves as a timing mechanism so you don't hit those thresholds and you have those estate taxes when your heirs receive it, correct?
that's correct. Yeah, irrevocable are more. That's more of the tax planning trust setup,
Mhm.
so to speak. Revocable, really, especially during your lifetime, there's no real tax benefit for a revocable trust. The revocable trust benefit is avoiding probate and not having a judge or a court decide, how much money you have in the trust, posting a cost bond or making sure there's inventories done for these companies, and you're sitting in court for 4 years before the judge says, oh yeah, you're now allowed to deed these properties or these business interests or transfer these assets. No, a trust is just, almost think of it like an insurance policy that's a payout on death. And I actually add what's called a pour over will into a trust, and that's my catch all. So anything that's not titled, and you can't do them everywhere, but anything that's not titled into the trust during your lifetime is poured over in your residuary clause in your will at death. And so it's kind of closing those loops. And so we couple a pour over will with a revocable trust. Now, in places like North Carolina, like I actually have several North Carolina clients, but I don't do their North Carolina stuff. I do their Georgia stuff. So they've got properties in both states, and there is some of a difference of opinion in North Carolina right now into doing separate marital trust, what's called like a SLAT, a spousal life. Those are more popular in North Carolina than they are in Georgia. In Georgia, what we're doing is actually a marital trust, just a single revocable trust for husband and wife as co-trustees, and then that trust becomes irrevocable at the death of the first spouse. In North Carolina, there's actually a big push. They're keeping those as separate trusts, and the thinking there is like you're just protecting each spouse's share during the whole time. But pre 2018, there was a lot more slats, grats, all those wonderful types of trusts that got popular for a long time. But in Georgia, with the estate tax the way it is, there's no state estate tax. It's just federal. We're protecting against. We're putting most of these in where husband and wife are. The spouses are both co-trustees of that single trust.
Okay, good to know. So,
A lot of
we're
information. Sorry.
oh no, it is, and this is a heavy topic, but I think
Yeah.
that we're not gonna have enough time to really tell everybody exactly all the answers. But at least we know some basics here and certainly that you need to loop in a professional. Um, now we understand a lot of our audience on the potential risks of not having an estate plan here. So one question we have here, which I think will be helpful to the audience, is what are some key questions we can ask? Let's say we have someone in North Carolina. What do we ask a North Carolina estate attorney? What questions, sorry, how do we find a North Carolina estate attorney and what questions should we ask them?
Well, the good thing about attorneys is we know a lot of other attorneys. And so even in states that I'm not licensed in, I'm happy to help you find somebody. Happy to connect you with my network of people. And one great place to start is actually with the state bar. They'll have a lot of resources in each state where you can reach out to them and say, hey, I'm looking for somebody that specializes in this type of law. But the other is really whether it's chambers of commerce, whether it's networking groups, trying to connect. My advice, and I think I mentioned it before, is finding that person you can trust is the most important piece. There's a lot of attorneys out there that can all do the same type of just nuts and bolts actual drafting that I do. What sets me apart, which is what sets all good attorneys apart, is building that trust over time and knowing that as your plan changes and as things, I just did one with a couple that moved all of their assets from Maryland to Georgia. Well, I didn't want to redo their whole Maryland trust into Georgia. They've already operated it for 10 years. They have an awesome, setup. So, but what we did do is we took everything from Maryland that they had that was good and kept it, but made it subject to Georgia law. Well, that was not a new trust. That was just modifying their existing documents. So it may be as simple as doing something like that. But it may be more complex. You may have to redo everything or do everything for the first time if you've never done it. The number one, though, is finding somebody you trust. And if you can't do that by contacting somebody at your local chamber of commerce or networking group, I'm happy to jump in as a resource, try to connect you with my network of people. I have people all over the country that I love to do business with and love to work with because, I don't really do business with anybody that I don't trust. So that's number one for me. So why wouldn't I advise my clients to do the same? I want clients to build that trust with their person first, know that that person's there for them. And there's no stupid questions. So it's not necessarily what questions to ask. It's don't withhold your questioning. If you think it's pertinent to you and you need clarification, this is your plan. This is your estate. This is your passing on. So you should ask all the questions, whether you think they're stupid or not. There's no wrong questions. There's only right questions in this world.
If we want to move your business property or primary property into a trust, do you have to quitclaim the deed?
You can deed it. It can be a quitclaim deed. It can be a general warranty deed or a limited warranty deed. It really just depends on how title should be passed. The only concern and something that everybody should look at when passing their primary residence into a trust is whether or not they're going to lose their homestead exemption. So if they're getting a big homestead exemption on their primary, they may not want to put that into a trust. I kind of do it both ways. A lot of my clients are higher net worth, and so they're not qualifying for homestead exemption anyway. So they go ahead and put their primary into the trust. And in other states, so like Florida, for instance, it's kind of similar to how Tennessee runs. There's no state income tax, but Florida is actually a very expensive state to die in because your assets have to go through probate if they're not in a trust. So I actually deed those Florida properties into a direct trust, not an LLC that's owned by a trust, because the LLC would still have to go through the probate process. So really, it's an asset by asset determination. A good probate and estate and a business attorney is going to look at each asset as, is this going to be taxable at death? If yes, how do we get it not taxable? If we can't get it not taxable, let's at least get it super protected from a liability perspective. So putting in an LLC or a holding company LLC that's owned by another LLC, adding layers of protection is always going to make you feel, and it's going to add, nothing is ever completely creditor proof. I've seen like one setup and it involves two offshore accounts held by some island, Cook Islands Trust and all that. Yeah, lots of fun, but very difficult to manage. Well, the more difficult something is to manage, the more protected it is most of the time. So not all of these revocable trusts are just, bulletproof, but they're a lot more than anybody else is doing right now protection wise. The majority, it's like 85, 90% of people don't have any planning in place at all. So you're already ahead of the game just by thinking about starting to do some of this. The biggest thing is there's no perfect starting point. You just kind of start.
Gotcha. We had one question I'll answer. Should it be an LLC or an S Corp? And that really depends on your type of business, as if it's active or passive. And you want to also evaluate some other tax planning opportunities or challenges with running the S corporation to see if that's appropriate. But if it's rental real estate, we almost never put it into an S corporation for capital gains reasons and also basis limitation reasons and other tax reasons. We have a question here. You could tell this is from a real estate, well, not really just real estate, but should these LLCs be in Wyoming? So we love our Vegas, our Nevada and Wyoming LLCs. What are your thoughts?
Yeah, Wyoming, Nevada, and Delaware are the three traditional states where you want to set up LLCs. With this whole FinCEN rollout, it's really not going to matter very much because everybody's going to have to file beneficial ownership. So, if that stands. So, yeah, I used to set up a lot of companies that were essentially ghosts where nobody could find any of the information about the actual owner. But there's now a federal law that's dictating that you're going to have to report that. So, a lot of the states just got a lot more friendly in terms of business filings. Georgia, we're just as competitive as Wyoming because, like I said, everybody's still now going to have to file this beneficial ownership information form.
Okay.
But yes, traditionally, like prior to this year, yes, Wyoming LLCs, no issue. I actually prefer Wyoming to Nevada and Delaware.
Okay. Great. Well, Jaryd, I know you have a hard stop at 11:45. You can tell that this is not only an important topic, but it's a multifaceted topic. So, if you have any questions and you are in the chat, I'm posting this. I just reposted your email address. Why don't you tell the listeners in their cars who are listening how they can find you and learn more?
Yeah, so my information is posted in the chat, but it's Jaryd, Jaryd. Don't know why my mom decided to spell my name that way, but she did. I didn't have a choice. Jaryd at B as in boy, A as in apple, S as in Sam. So BAS attorneys, ATTORNEYS.com. And I'm happy to look at your emails. And if it's something that requires a little bit more robust Zoom call, phone call, happy to jump on that with you. And yeah, it's been a pleasure to join today. And as stated, I do have a hard stop. I got to get my wife to the airport.
Very important.
So that is the number one requirement. She's my number one client, so I always got to take care of her. But it's been such a pleasure being on with everybody today, and really look forward to doing it again, hopefully soon.
Awesome, Jaryd. Thank you so much for your time. Everybody, I hope you enjoyed this. You got his information. If you're interested in being a client, obviously you go to markperlbergcpa.com to fill out our application. Really, really important stuff here. Thanks again for your time. And also send me some tax accountants, you guys. All right.
Yes.
Come on. How come
Thanks,
you
guys.
podcast listeners aren't sending me any tax accountants? Send them to our site. All right, you guys, have a great rest of your day, and we'll keep in touch.